going to allow for a range of other things to happen serially once the consent has been given. Now, this consent architecture seems to have become very important for fintech companies and the way fintech companies are going to work, especially in terms of recovering the money that they are actually on. But the consent architecture has also become important when you look at the national debt stack, where, and I just want to read one passage from the national debt document in the DTI. The way the data that's being collected about each year in terms of health, the way it's being viewed and why we have anxiety. It says potentially it places India at the core of medical research in the world. This whole idea of creating the national stack. The design is geared to generate vast amounts of data in some of the largest health databases. Now, this idea that if you have a largest database of anything, it is some, it makes you some kind of a digital emperor. I think that will need to be questioned again. Because the larger your database, there are many more elements that you are introducing in. So, if you have a large database, then you're looking at this as the entry into the global market on health data. So, a lot of this research is going to be on data that is collected from people here who are going into the health system. It will be the largest database that will help in medical research all over. This is the vision. This is not, I won't even call it a plan. This is a vision that this document gives to us. And it, this is the point at which I pause and say that the people like me are now uncomfortable with using the word data. Because data makes everything sound neutral. There is nothing neutral about the kind of information that they want to gather through all of this. So when you say data is the new oil, it's not like oil is the new data. We are not talking about material. We are not talking about resources in different places. We are talking about the human being as a resource. And we are talking about our information as becoming a resource on which businesses are going to be built. And it's, over the years from about 1978, 79, I personally, but many other people have watched work issues like the state says that anything below the soil belongs to the state. So minerals belong to the state. And then the state can decide what to do. Then all water sources belong to the state. Cannot be rivers, streams, whatever. Now if they belong to the state, in law we have tried to devise principles like public trust doctrine. So that you say you are not the owner. You are merely someone who has to manage this so that for the better good of the people of this country. So it is not your property for you to convert into to hand over to other people. So privatization of rivers, of streams, these have all been contested on the basis that the state doesn't own this. But the state is constant. There is a amount, for instance, there is a law which says that everything, all water bodies in this country, the state, belongs with the state, the 1975 law. And others can use it till the state decides that it wants to take it over and either divert it or use it for some other purpose in whatever way. So there is a lot of assertion of ownership of these resources. Then it came to land, and I think land everybody is much more aware of than water and even mineral resources, because the contestation has been very high. And there are, for instance, there's a land conflict watch website which has been created. Because there are pitched battles that are happening across the country. Because land is one resource that links generations in terms of ability to sustain themselves. And land is also one thing which is demanded by every company which wants to set up. So a lot of this idea of development is linked with the ability to take over land. And a lot of the idea of survival and sustainability is also linked up with an intergenerational equity. It's also linked up with not allowing that land to be taken away from you. So it's this conversation has gone on. Now it seems that, for those of us who have been studying those systems, it seems like data has reached that place. Personal information has reached that place where the state is saying, I tell you to give information about yourself, you better give that information. And we will figure out, there are many people who want to do business with it, and we are going to facilitate them doing business with your information. Your information is not yours for you to deny. So when the government went to the Attorney General went to the court and said that you can't refuse to give biometrics because your body is not your own, it belongs to the state. not something off the cuff. Initially, all of us laughed it off. And then when we went back to it, we found actually this is the progression through which we have actually gone. And we can either decide that we agree with it and give whatever they want, or if we say that, for instance, tomorrow, this is a hypothetical, if tomorrow the government says that all those who have kidney failure, who have had kidney failure, will be entitled to take one kidney from one of the other persons. All these are resources. The kidney is a resource. How would we react to it? Would be okay, after it's fair, it's equitable, it's just. Why should you have two kidneys if somebody else doesn't have even one? Why should a 30-year-old person die without a kidney when it's 60 and when I have three kidneys? So you can recast this whole debate. Now, am I exaggerating by making the personal information seem like a kidney ownership? In my mind, no, because there are various things that are linked up with this idea of personal data. Personal data is not just about whether you know about me or not. There are many places we do an interviews us. There are many places where we leave our information. It's not like we've never done it. We are only proposing something that converts our personal information into a product or into a resource for a product which has many implications, none of which people are willing to consider. So this, in that sense, is not really an attack on technology. It's on the uses of technology. It's because it is possible to convert this personal information, to converge this personal information across multiple databases, and to see what you can do with it. Either as somebody who wants to create a market or to reach a market, therefore wanting information on people, or wanting to create other kinds of products and services, which can become the new business pattern. Now, if that is the idea, then I think we do have a right to be concerned that personal data is getting converted into this kind of a resource or this kind of a product. To have this happen, the state has had to assert a different kind of power over us than they have ever done before. Earlier, the power was over land, over water, over mineral resources, over forests, over trees. This is the first time they are saying relationship with them, but your relationship with yourself. That is in question. Now, is the government doing this on its own? To our mind, it is not doing it on its own. It's not doing it on its own. And where did we get that from? And I go back to the principles in a bit. In 2011, there was a document that was prepared. It was at the beginning of the UID project had begun. There was no law, there was no feasibility report, there was no background study. We were asking questions, no answers had come. In the meantime, in this unique project, which I must confess, for the longest time I thought it was a unique identification project because biometrics are seen as unique. It's only later that we realized that the unique word is not being used in relation to biometrics. The unique word is being used in relation to the number. Every person should be uniquely identifiable by the number. That's why among the early documents that was prepared in the UID project, you have a document called UID, a numbering scheme. It is about numbering people. And the uniqueness is about each person having a unique number. It's not about, because we wondered, we said at that time, nobody had any idea what biometrics was doing and whether it would work or not. And we said, how are they putting all their uniqueness into this? So we later realized that that's not what we are doing. So in 2011, in January, there was a committee report that was given. This committee was called the TAG Up Committee. It's called the Technology Advisory Group on Unique Projects. The chair of that was Mr. Nilipani. And that committee said that they were dealing with basically they were dealing with 5 streams, revenue streams. So the idea was how do you leverage technology so that you can make these more efficient and that you can manage this information better. So the report begins, and early on in the report they start with saying that this is going to, that government has a lot of data. No ability to manage the data, and they don't know what to do with it. So what should be done with all the data that is with government is that it should be handed over to companies, private companies, that are set up for the purpose of receiving this data. These private companies can have between 26 and 49% shares which are government shares. Not the controlling share will always be with the private entities. Now these will be private, the language is used and I'm still trying to decipher it. They will be private companies acting in the public interest and profit making but not profit maximizing. Apparently this is the jargon that has been created. I haven't read too much of it, so I see it. Then they say that these will be natural monopolies because you're taking it from the government, you know. So when you take, suppose you say that all the income tax information is going to be given to one national information utility. That's what they would be called. They'll be called national information utilities. These NIUs would be collecting all. One of them would have all the income tax data. So obviously they'll be natural monopolies. But because it's in a market economy, they can't just say yes, these will be monopolies. So they say there will be natural monopolies, but anybody can compete. Don't ask me how, but anybody can compete. And then you find that very soon, this is 2011. In 2012, Mr. Pranab Mukherjee, who was then the finance minister, in the budget, he says that GSTN. Now we must remember that the GST bill had not been passed. The GST discussions were still in its early stages, but he already announced in that budget that the goods and services tax would be an NIU, the National Information Utility, which means that it would be a private company which would move all this data with it. In 2013, the GSTN had already been registered. Till 2016, it didn't even begin, but by 2013, they had already registered it, all ready to receive all governmental data that comes through this process. Then the conversation starts when Mr. Nagpur, as his chief spokesperson, starts telling us what we should expect from this GSTN. And they say the point about the GSTN is that it is going to collect, it will get directly from the people. It will get from businesses, it will get between 2 billion, 5 billion vouchers every month. Algorithms will be created so that businesses can be created. Now, when you look at the GSTN, you find that there is this talk of formal economy and informal economy. So, all the money that comes in and all the business interest that there is will enter the formal economy. At the same time, those of us who've been watching what is happening in other domains find that the working population is being made more and more informal. So the labor laws are taken away, inspectors are taken away, they become facilitators. So if the company, in payment of wages and related legislations, if a company does not follow the law, they will not be punished for it, but they will be charged. A facilitator will go and tell you, very bad, you should have followed the law, let me tell you what the law is and explain it to them and get them to follow it. So this is the kind of change where the people who are working would be hired, fired, contract labor, whatever. So there was a whole informalization of the workforce while you had formalization of the money systems that were being created. So the money drain was being created in this. And this was one of the major projects that produced what are called digital footprints. This is language familiar to you. I said what are called because in many other audiences where I speak, they have no idea what a digital footprint is. So this is part of that process. Now of course, and I'll just end the story with this last part, which is that so this GSTN has been set up. We have seen huge conflicts of interest in this case because Mr. Nilakani is chair of the tag-up committee report, and then he goes on to say that he's been working with the government on setting up the GSTN, and then he goes back to Infosys. Infosys gets the biggest contract in this. So there are many questions to be asked in this. But the privacy element in this is where you have, actually this should be the least private, all of us should know and we should be publicly talking about it, but it's least talked about. In the GSTN, you have UID being introduced, and you have to be registered with the GSTN number. It helps the aggregation of data about people by this company to happen with the greatest ease. And the responsibility, see in the tag-up report, the one other thing they say is if all of you know egos, garbage in, garbage out. So many of these things, partly because of legacy systems, and partly because you have these Whenever information is fed and there can be many errors, they say that there can be a lot of garbage that goes into these systems. So what do? You put the onus on the person who has to engage with the system to clean it up. So you call it a self-cleaning mechanism, where people have to come and clean it up themselves. So this is the kind of, so you have to go and become a reporting citizen, where you have to keep reporting and cleaning up so that somebody else has completely clean information about you. This is how data is being created and this is how we are seeing it happen. So the last part of the story is where the government now seems to want the GSTN to become 100% government, which is a new turn because in everything else privatization is happening. Here that which is private is sort of being made government. So that they will be able to create their own algorithms to see what they need to see and what they need. So that's a different story that's going on. This is how we are doing the data story. And when we are reading the data privacy principle, the privacy principle, we are testing each of these which are emerging now against these principles. I'm telling you all this also because when the Shri Krishna Committee report comes out, it's going to be placed under a lot of scrutiny. One of the reasons for that scrutiny, two reasons at least that you can think of for that scrutiny. One, it's because this is not a committee that was thought of because it was necessary and because they were going to do it. It was announced in the court during the course of the privacy hearings before 9 judges. And it looked very much, and as it proved later, it did happen, that these 9 judges were going to be friendly to privacy and unfriendly to those who want to take away privacy. So at that time, because the UID project, this whole privacy thing came up in the context of the UID project, the government stepped in and said, no, no, we have set up a committee. And that committee is now going to produce a data protection law, a framework. And when you see this committee, unfortunately, therefore, the other unfortunate part of this is that the committee that was set up is not a representative committee. The APCA committee, it called us all a committee of experts, and I can say quite honestly here that nobody was an expert at that time. I suppose we need to call people experts so that it has some credibility. I was a member of that committee, and I can tell you I was no expert at that time, but we worked really long and hard on all the different kinds of people who had themselves were experts, so that we could learn what to put in. It had multiple voices and multiple interests in that committee. This committee, unfortunately, has Mr. A.B. Pandey, who is the UID AIG. It has Arya Sengupta, who appeared in the Supreme Court in the privacy matter to say that people in this country have no right to privacy at all, and who's been claiming, and I think rightly, that this team, which is called Vindhya team, that they are the authors of the Aadhaar Act. So they are people who've been promoting this issue. The other members of that committee who at various points in time have spoken up saying Aadhaar is a good product. So with this kind of a committee and setting it up at a time when they are trying to save the UID project, it didn't honestly give us too much hope that this is going to produce anything that will be fair and that's going to make a good law. And that's where we are still positioned because after the committee was set up, many people wrote to the chairperson and we also spoke to him in public consultations to say that your committee does not have credibility because of these reasons. You must take on board other people who don't necessarily think the way you do to challenge what you're going to put on board. Especially when you're going, if you haven't done it so far, when you're analyzing the replies that you've got from the public, at least at that time you must have different points of view represented on it. What we instead got, first they've been resisting RTI applications to say how they are functioning, and then finally we got one set of people got one round of what had happened. And what we find is that RTI reply is that at the meeting that they had in the minutes, we find that RGS and Gupta's team is going to be, they've made some 4 subcommittees and they're going to have 2 people from, 2 people each in those 4 committees from RGS and Gupta's team. And they were asking Mr. Sharad Sharma to come on board and possibly use him to consult. I think all of you know about the trolling episode that happened in relation to Aadhaar. This is Mr. Sharad Sharma who's been heading the iceberg. And this is all publicly documented, so it's not like I'm saying something about a person which is not documented. Now, asking him to come on board was like basically saying, you cannot say what we want, we've decided what we are doing. I don't know if Justice Sri Krishna himself recognized the implications of this, because he's not been either here or there on that, and he's been saying that he's not going to allow surveillance to just happen unimpeded, and he will put his foot down on it. But with this kind of functioning, we are very apprehensive about what we get. So we've gone back to the privacy principles of 2012, not because it is the most and best and the most really fond or best principles, but because they form a basis for testing other things. Not for, some can improve on it, some maybe, like now we are testing it against the GDPR, because the European standards are much higher in terms of people's protection. Just like the American standards are, promote industry and promote business in a much bigger way, and say that people's rights can, it's not like they trash it altogether, but they say that, we can't be concerned with that at this stage, we want innovation. Now, the Europeans, of course, have told us that with privacy, innovation is possible. So why do you have to talk like it's either innovation or privacy? Anything new that comes up has to conform to certain ethical basis. And to say that we will continue functioning without an ethical basis, and then at the end of that, we will have a legal or ethical norm which will suit our product, that makes no sense. So there have been all these conversations that have been happening. Which is why I'm going back to these privacy. So consent, I think we need a lot more work to be done on it. And it seems like there is a deliberate attempt to dilute the idea of consent by bringing in various other terms and terminologies which will help dilute. The third is collection limitation. Now we found that the greatest resistance comes to collection limitation. Why should somebody who asks you for information have to tell you why they want that information from you, and whether and establish that it is useful and necessary what they are doing? Can someone just come and say, I'm going to collect information and I'll decide what to do with it later? The whole UID project is premised on this. When it began, they did not tell us what they use it for. There were certain marketing things that they said. They said, oh, we will, we'll make it corrupt, we'll make TDS corruption free, we'll make it leakage free. Then why were you taking it from the whole population? When you took it from those who are on PDS lists, and they found that they could not, then you didn't stop with that, because you put 3 levels. You said first enroll, get a number. In the meantime, you have to go through the whole process of getting a ration card, which establishes that you are entitled. But your entitlement doesn't come in till you link your UID number with your ration card. And after you've linked it, every time you have to go and put your fingerprint. If it doesn't work, you won't get your entitlement. It may work this month, it may not work next month. It is not the problem of the system, but the problem of the person. So I'm being told, if I'm DPA, I'm being told that I should make my fingerprint work. You're all technologists, tell me, can you do it? So there is something that has happened in this, these plainly, and now we are seeing that, say, in fintech and in all these payment banks and all the rest of it, they are looking for two-factor authentication, which does not include biometric. So there is, in the Vattel Committee report of 2016 December, they said we don't want biometric. Why? Because there will be connectivity problems. In many places there will be connectivity problems. And the machines may not always be very good, it may not work very well. Isn't that true for PDS? How is it any less true for PDS? So this idea that you have to get everyone database, get everyone onto their primary database, and then, like Mr. English kept telling us, I must give it to him, he always told us what he was going to do. He said, this is not just some identity, it's not just an ID. It is it is to create a platform. This is an identity platform. And many apps can be built on it. So the idea was businesses would be built on it. So you first get everyone database. That becomes an identity platform. And then businesses build it. People build their businesses on it. You have not anticipated what it's going to be. You have no idea what kind of implications it will have for a population. Nothing. But then this is how innovation is being thought about in this country. Since your persons in technology are telling you, when I started working on the project in 2009, people were excited when they thought of technology. Everybody was something new coming in. There were many things that we did not have before. It was at home. one 1960 film which your grandmother would have told you about, suddenly you can see whether it's really exciting or not, just by switching on something. It was great. It was a lot of fun. The UID project has systematically denuded the excitement about technology and brought in fears. I feel bad about it. I'm not a great person for using all the technologies in the world, but I think when there are products and processes which can enhance the quality of life, it shouldn't be brought to a pass where that enhancement of quality of life becomes a threat to people. And start seeing it even when you use it like mobile phones. People use mobile phones all the time now. If you used it 4 years ago, you were using it merely. Today you say, oh my god, this can be tracked. I don't know who's watching this. I don't know who's collecting data from this. Because we are living not just in information asymmetry, but lack of information even among those. Lack of an understanding of what they are doing even among those who are collecting all this. So the idea that they should, in law we say that if you have to have a violation of privacy, it should be proportional to what you are trying to achieve, and it should be proportional in terms of how much loss of a right you are proposing to people. There is no question of proportionality if you don't even know what you are fighting for. People just now blindly want to collect all the information that they can get. Any data protection law that does not prevent this from happening, where without saying why you're going to use it, you can just collect information. And any source that you can find if you're going to pick up and collect and keep and aggregate and use information. That is not an acceptable thing because today we are not talking about some information. We are talking about information about individuals, about people. And it has implications which range from personal discomfort through political dissent and political engagement to national security. Because if you're going to have these kind of databases, one of the early things that I heard was you can't use the word electronic and secure together in the same sentence. You do take a chance. Every time you create this, you do take a chance. And then you assess what kind of chance you're taking. You put in place certain kind of protection so that nothing affects people too much. But here we are talking about the collection system which is people have gotten mad. I mean, I look at all the data collection happening everywhere. And they say let's keep it because data itself can, if I have data, I can sell that data. And if I have data, maybe I can create some product out of it. And honestly, I mean, I'm also old, so I find that many of the products that are now being offered to us are so juvenile. And I'm thinking, are you really putting my rights at risk for this kind of product that you want to give me? You can play it like a board game. You can't take it seriously. So this collection principle is something that the Sri Krishna committee, even in its white paper, was not willing to consider. So they went past it. So for them, data protection was about protecting the data that they've already collected. But actually, privacy principles led to data protection principles mean that collection itself has to come within that notion. That you can't simply collect it. So that's another thing that you're going to watch when you're see this stuff. The fourth principle was purpose limitation. And this is a huge problem that we are having. A lot of the time data gets collected. You have no idea why it's being collected. It is collected for one purpose and then used for another. Function creep sets in. Mission creep where it goes from one kind of purpose to another kind of purpose. A hospital which is collecting information about you because it needs to treat you, ends up treating that as a resource which it then uses maybe in research, maybe in getting into some global kind of agreement with some other hospital somewhere else, which completely changes the nature of this. Maybe in sharing it with the government in relation to the national health stack, where you don't even know what is going to happen with it, because the vision is only about getting lots of data. And then becoming some kind of global element, digital element. So we really need to think about purpose limitation because without purpose limitation, you can't have any justification for collecting that data, and anything beyond that purpose can only be done if you have informed consent from the person whose data it is. Otherwise, you cannot give it. There are exceptions to this. When we discuss surveillance, we were saying that surveillance, you can't say there can be no surveillance at all in a country. there are situations under which you put people under surveillance. That surveillance has to follow a procedure where whoever is placing another person under surveillance has to maintain a record of why they have decided that surveillance is necessary. They have the authority to authorize that surveillance, and there has to be a time when surveillance ceases. Surveillance can't be indeterminate and forever. In many such situations, we were saying where nothing goes wrong with it, you have to inform them. In other cases where the surveillance results say in charging a person with a crime, that becomes public in a court case. But somewhere, a state can't become secretive in mounting surveillance against people. Now, if there are in purpose limitation, if a court, for instance, says, it authorizes that information which has been collected by a bank, for instance, has to be made public to deal with either a fraud or theft or whatever, then that kind of moving of purpose is something that is legal, open and permissible. But you can't have function fees saying, I collected it thinking I will use it, for only giving, I'm FedEx and I collected your data. I took two, like now they're doing, one or two, for KYC you have to give one or two documents. I collected it only to give them the book, but later I found that it's actually useful for me to convert it into, I can do some more businesses with it. Why this has become a problem is also because unlike earlier industry, where if I'm running an aluminium plant, I may end up having fouled up the environment, I might have affected people's health, whatever. Those are the effects, all out of what of my running the plant. Then I may be answerable for it in various ways. But my fundamental business is only running that plant. Today you're finding that all these agents, all these institutions, all these companies that have come up, they start with saying that we are giving you Gmail, we're giving you a mail service. We are delivering parcels to your doorstep. And then, we are giving you a program on which you can run your computer. And then they collect data from that. And then they say, okay, we've been watching all that has been happening. Now we can do health prediction. So we will say which are the places where there will be dengue, which are the places where cancer is going to increase. And then we'll also tell you which are the places there are doctors, and we link up those doctors. And so we do treatment, preparation. We also do predictive analysis, and this is so you enter into that. And then you say, okay, these are the places where we don't see people using their laptops between this period and this period. So we think maybe that's because there is no electricity in these places. So let's enter into the power sector and see if we can get the power sector. So this kind of database companies that have come up are not conducting one business, they are getting into multiple areas, some of which they may understand something of, many of which they may not really have anything to do, but they are everywhere. So when they start entering our lives in this kind of a labyrinth, where every part of our life may be touched actually by the same company, then we have to start asking different kinds of questions. Purpose limitation there also becomes a significant issue. The fifth is about access and correction. I think one of the most interesting things in the Aadhaar Act is where they say that you give your biometrics, right? And then they have the biometrics, but then they say that we are not going to show the biometrics to anybody, no court can ask, nobody can ask. You also can't ask. I won't show you your biometrics because I am protecting your privacy. Actually, it's the most bizarre provision in the whole law. Because of course, then when I asked somebody, they said, what will you understand if you see it? I said, if I will understand nothing, why are you worried if I see it? It's my biometrics. But you will not show it to me. So there are many theories about why this is happening. If you look at that act, you'll also find that you can ask for certain protection. What is the information being held about you? And then you can also put in an application for correction. So they may or may not accept the correction, which is correct, because they can't just accept anybody's correction. I can then say things which are not accurate. But that idea of access and correction is a necessary part of any privacy and data protection framework that comes. Access cannot be restricted for the person whose data it is. That's a primary principle. You can't tell me you hold data about me, but but I am not entitled to know what you hold about. And any system that says this cannot find validity in a proper privacy and data protection framework. The sixth is about disclosure of information. So you have information about me, you are a company, you have information about me. You can't decide that you're going to disclose it. Like we saw in the, we saw it in the context of notice when it happened with the NSA. This can happen anywhere. And then you disclose information. You should also remember that in this country, most of our security and intelligence apparatus is not governed by any law, it's not supervised by anybody. Many of them are just under the Home Ministry, some of them are just under the military, under the military establishment. So none of us has any idea how they are functioning, what they are doing, what data they have about us, how are they interpreting their data. I'll name no names, but let me give you one instance of the kind of thing that happens in this. There was somebody who had been tipped to be made a High Court judge. So they sent the IB out to get a report on the person. So that IB chap went around and made some inquiries and went back and said that this guy is an alcoholic, so he should not be appointed. So he was not appointed. Some years later, his name came up again because he was considered a good candidate. And it was found that the reason that the IB had said this was because his friends called him Boozer. They called him Boozer because he was the only one among them who did not drink. Now this is how information gets transmitted. He had no means of correcting that because he had no access to that information. So a judgment had been made about him without his ever being able to correct that judgment. So this, the idea of disclosing the information to somebody else and allowing access to oneself, these two have started playing out in a very different way after the UI based one. So you don't have access to your own information, but disclosure is happening in multiple sites. Many people, and there is no notice at all of this disclosure which is happening. These are basic principles that have to be followed. The seventh is security. This is really the trickiest. I don't know how many people are going to solve this problem. If you're going to keep creating more and more databases of this kind, you're only creating more and more scope for breach of security. And we have seen, I think Hyderabad has produced a maximum number of instances where you have established cases where security has been breached. And the breaching is not that you don't have to go into a data, that has also happened, right? The Rajna Khaira story review clearly showed how you can have backdoor entries and it's very easy, even a person who doesn't understand technology at all can walk in and pick up information and walk out. Maybe not physically, but walk in and walk out with information. And yet we have been unwilling to see that the rising insecurity because of this kind of database being created needs to be addressed. If you cannot, I won't even say you can't guarantee, because there are many things that can't be guaranteed. But if you can't at least ensure a level of security that does not put people at risk, if you can't even guarantee that much, then how are we saying it's all right for all this data to be collected and to be kept? So this the idea of security is it's being debated ad nauseum, and always it comes up with the same conclusion that we can never assure you that it will be secure. We just do the best that we can. You think about what the UAE project has done and the various ways in which security is compromised. The three words, like I was saying last time, was unique, ubiquitous, and universal. The idea of the project itself, when the project began and we read all the documents that they had on biometrics and realized that they really did not know whether it would work, that they might, with a range of things and over a period of time, make sure that every person has one number, except a few here and there. They still would find it difficult to use it for authentication and for any further purposes. And then you have to go on updating your biometrics. He said this doesn't sound like the reason why this project is there. And which is when we realized that it is about the number being put in multiple databases. Now this number being put in multiple databases means that if those databases get reached, your information gets reached along with the UID number. So when 210 databases got reached and they were available on the net, it basically meant that with your UID number on it, with your mobile phone number on it, with your bank account number on it, if you collated the information that different people would have in different databases of these, you'd be able to create profiles of a large number. Why would we want to put people at risk? Is this how we want to use technology? Is this our idea of what we do with information and how we use technology to deal with it? So it's a big question, and it's a question that somebody has to answer something. The next is openness. You know that the RTI information, the RTI groups have been asking for the longest time for openness of government. So in the RTI framework, there are two kinds of things. One, you have the proactive disclosure, which means that there are policies, there are various things that happen to the government, which the government has to inform people that you shouldn't have to ask for it. It should be out there. And TRAI, for instance, has been doing a pretty good job of putting all this stuff out for consultation and also making available the answers that come, the kind of responses that they get. That's a kind of openness that is practiced. But the other kind is where you have reactive, which means that I ask you a question, an RTI question, and you have to give me information. And they've been finding that there are various ways in which information does not get given and openness is not practiced. The classic case for us was when the National Intelligence Grid was set up. And this National Intelligence Grid was saying that there are 22 databases from which we will be giving real-time information to 11 security and intelligence establishments. That is why it was being set up. When we would keep asking them, they would keep telling us, no, there is nothing in this project. We are just a pipeline. It will just go through us, that's all. We don't even see this information. So there is nothing, we are not threatening you at all, there's no problem at all. Then they made a presentation to the cabinet. When they made the presentation to the cabinet, one of our friends filed an RTI saying we just want to see that presentation. Which means what? We are asking to know what the NATGRID project says it is going to do. We were not asking for information that the NATGRID project has collected. We are saying what is the project? The answer didn't come to the first 20 days, 23 days, 24 days. And then an answer comes saying that this month, between the time that the question had been asked and we gave the answer, they had notified that it belonged in the Security Act. So if your NATGRID is not really doing anything, that requires it to be treated as an intelligence or security apparatus, and it's only a pipeline, there is nothing else that they're doing, why do you suddenly become a security establishment the moment you have to answer an RTI? This is the kind of lack of openness that has been bothering the RTI. The third kind of way in which it happens is actually through this idea of privacy. One of the exceptions in the RTI Act is where they say it is privacy, then we have to ask if it's private information about the person, whether it's a bureaucrat or a parliamentarian or whoever, we have to find out from them, give them a chance to answer. The commissioner will ask the person whether there is any privacy thing, whether that information can be disclosed. If they say that privacy interest does not allow them to disclose it, actually the commissioner is supposed to judge whether it is in the public interest that it should be disclosed or it is not, and it is really only a privacy issue. Most of the time they take shelter behind that, and many commissioners are wary about breaching that because it is powerful people in position, they don't want to get it. Whereas all of us are being asked to be open. All those in power are saying don't ask us because this is privacy. But the idea of openness therefore has been liked by these kinds of things. Now, sensitive information, everybody agrees should not be made, not everybody. Everybody in civil society and in the RTI movement agrees should not be made available. There's no question of openness about that. So, for instance, when the UIDAI is saying that you have to put your UID number into, if you want to get ARP, right, antiretroviral therapy, because you are HIV positive, that is a complete violation of every privacy law. Because you are not expected to be open with something that is sensitive information about yourself. People knowing that you have, that you are HIV positive and that you are undergoing this treatment puts you at risk. So you should not be asked to do this. But the UID, the government has issued a has said that NAC was asking that you should give your UID number. Why? Because they want to be able to track you to give you the medicine. So there is a way, on the one hand they say we want to convert everything into DBT and give cash to people, poor people, and not provide services. Because if you provide services, you are not giving them a choice about what they spend the money on. And that is paternalism. On the other hand, they'll end up saying that we need to know everything about you so that we can track you to make sure that you take the medicine. So this is the conflict or openness that's been going on. And the last part is on accountability. Accountability. Actually, sorry, the last part is on accountability. Accountability is usually, there are various ways. Now, you need accountability only when you have all this, when you have people who are collecting data, and you're using data in various ways. So, accountability has to be to ensure that the data and privacy principles are being followed. So, you need some kind of a regulator who will then make sure that all of this is followed. Now, if you're going to have a consent regulator who's part of the apparatus, then you're not going to get anything that's going to be free and fair. That's what we were discussing just before the session started on. So these are the privacy principles. Now tomorrow or day after, whenever Justice Sri Krishna's report comes out, we will be testing it against these to see whether it improves all these, or whether the whole, like we suspected in the beginning, unfortunately it didn't acquire the credibility we would like it to have. Because it started with trying to save UID. So they might as well have called it the Save Aadhaar campaign. Because when the court was questioning it, they quickly ran and set this up. Now, when the court has been hearing the matter, they've got all the people who will support the UID, and they are trying to, put things together. We've seen the white paper. The white paper is completely, it is totally not respecting the privacy interest at all. And this comes after the privacy judgment. At this point, I just want to say one thing about privacy. Privacy is really not, and I don't expect you to read the judgment, so I'm telling you this. Lawyers read it and worry about telling you this. When we say privacy, very often we think in terms of who knows about me, what information about me is getting into various domains, and that is all there is to privacy. Privacy in law and in constitutional framework is a far deeper phenomenon. When you look at privacy has been recognized today as being part of the fundamental rights in our constitution. Now the logic of fundamental rights is not just that we have rights. Of course we have rights, but that's not the only logic. What's the value of us having rights which are constitutional rights? These rights are recognized by the constitution in a way that the state cannot take these rights away when it is acting the way it is. So, there have been two ways in which, there are two things to say in this. One is that the RTI, which is slightly different thing, where the RTI was seen as making the state transparent to the people. Projects such as the UID are seen as making people transparent to the state. When you look at the voluntariness that was promised in the UID and choice, you find that has been replaced by mandatoriness and coercion, with the state saying you either get onto this database or else. So it is by coercion that many people have got onto the database, and every system has learned to adopt it. The state has been completely lawless in the way in which it has functioned, because there has been no law for the longest time. When you bring in a law calling it a money bill so that it can't be debated in the Rajya Sabha and there can be no changes that are brought to it, the Supreme Court has been passing order after order after order saying you can't make it mandatory, you can't deny anybody services because of this. Then they said you can't use it in many of these cases. It made no difference. In the first instance, in 2013, when they passed that order saying that you can't deny anybody any service because they don't have a UID. Soon after that, the UIDAI and the finance ministry, I think, and the oil marketing companies went to the Supreme Court with their affidavits and said, please allow us to make this mandatory. The same UIDAI, which had been saying, oh, this is voluntary, enrollment is not mandatory at all, went back to the Supreme Court to say, please allow us to make this mandatory because this project is going to solve all the problems of this universe. So I'm paraphrasing it hugely. But it was very much like that, saying that this is going to be the solution. And we need it. We need everyone on this database. It was a 53 or 56 page affidavit making an impassioned argument. And the court said no. They said, okay, if you don't give permission, I'll do it without your permission. Just like a teenager. You don't give me permission, okay, I would have done it with your permission if you gave me permission. If you don't give me permission, I'll do it without your permission. So they carried on. See, the lawlessness of a people is managed by the laws that are made and by the various kinds of state systems that are put in place. How do you deal with the lawlessness of the state? You go to court. So you expect that the court will understand what this is. But you must also remember that courts are not immediately going to jump up and say, oh, lawlessness. The court sees the government as at the same level as itself, performing different functions, but it's not going to likely tap off what the government is doing itself. So it has taken all this time. In fact, in the court, it was very interesting to watch and see when the petitioners were arguing. All the judges who were listening to the case, they were like, okay, we know what you will say. You'll say this project is bad, you're saying it's surveillance, you're saying exclusion, you're saying companies, all kinds of companies holding our data, you're saying privacy is affected, you're saying data breaches, you say national security, okay, we've understood all that. Now let's hear what the other side has to say. So we know what people who complain about the project like this will say. The other side will have answers. When they started hearing the government's argument, I have to confess that this is the first time that I've been in the system for a very long time. I was also a reporter from the court for 7 years, so I really watched it very, very closely. I don't think I've seen any other case where there was no argument. Which is why you find that the Attorney General, changed Attorney General this time, he read from a document. He said that the CEO of UIDAI will come and make a PowerPoint presentation on the project. That's not a constitutional argument, that is just a PowerPoint presentation. So he should have made the constitutional argument. So the judges told him, okay, and the petitioners were also saying, but we'll hear your argument first. And he said that PowerPoint presentation is the argument. When, however, he had to continue, till it could be done, he had this document, a World Bank document, which the World Bank thanks Accenture for. And he was reading from that document as his argument. So this is one case where the only argument that they kept initially making, which unfortunately for them got blown away, was the argument that this project had resulted in a large amount of savings. So initially they had said that in LPG there had been a savings of
some 90,000 crores.
Now they said, you can say any figure, I don't know why they said 90,000, they could have said 900,000.
This figure was in the first keynote from the chairman of UIDI in the Delhi conference. 90,000 crores on some 5 different schemes that he. Such a presentation.
Yeah, it's very optimistic, and I think all of us should live with optimism as part of our lives. But it doesn't make a good argument. So you're right. I mean, having made all those statements, they were not able to establish it in court. And it was techies who helped us unravel it. It was economists who helped us unravel this. So it's been an extraordinary coalition of people working on the ground, like Aruna or NKD, Elizabeth Wilson, and then you had some people who are retired army people. Colonel Matthew, for instance, was livid because he said, I've worked with these systems and I know that what they are producing is complete trash and you can't allow this to continue. Let there at least be an immediate audit of what they've done, what they've got. It's never happened. And they've never allowed anyone to see their data. And then you had the persons from technology who came in to explain that what was being said was not at all what it was. You had economists who went back to the ground to see whether what they were saying was actually happening or not. And finding that not only was it not happening, it was disrupting systems that had been set in place to deliver services to the world. It was disrupting. And it was affecting large numbers of people. And in the middle of all this, you have a thing called disintermediation. Intermediation is when and I'm giving a very loose definition. Intermediation is what the civil services are supposed to do. You have the state, you have the people. The collector is supposed to know what the state is saying and know what is happening with the people and intermediate. Now they've said, now the technology has come, you have to disintermediate. Which means what? People don't need to meet, and they actually say that in an EPIO document, in that vision document 50 years old, where they say that if the bureaucrat, if the administrator meets the people, there will be corruption. You don't meet. Do it through technology. All this is resulting in a huge divide. This is not just a digital divide. Please don't think this is just a digital divide. This is a divide between populations who have always found it difficult to reach the state and speak to the state, and the state. A huge divide. And all this is being done, and everybody can see it now, it's being done in the interest of business. For many of us, business is a good thing. In fact, when Mr. Modi keeps saying you have one business and then you have 5 people to be employed, and I actually don't think that's a bad thing at all. And there are many people who don't think it's a bad thing. Small businesses, medium businesses, micro, good things for them to happen. But when you do them on the backs of people whose backs are already bent, that's not good. And when you do it by, and right now we are finding that using people's information about people, converting people into fodder for industry, that is not acceptable. That's what this data protection, when we read the data protection principles, that's what we'll be looking to see. We're looking to see, does it protect the people and does it shift it away? Can you say that, oh well, you have something I want? Actually, this is a theory that's coming now. Trickle-up theory. You got a trickle-down theory, right? So you create a big fight, then something will trickle down to the last person. That didn't work, but anyway, I mean, I've witnessed the shifting contours of poverty over 50 years now, and I can tell you that the shift had happened. What I saw in the 60s and 70s had changed by the late 70s, by 80s. How you recognize poverty had changed because the level of deep poverty, which existed in the 60s and 70s, we had managed to move our way out of that. It's not like starvation deaths never happened. In 1988, we had a case of Odisha, because Kalahandi, which is among the lushest places, used to have starvation deaths. But the pervasiveness of deep poverty had definitely come down. It worries me that I'm seeing a return of some of those signs today. And it should not be happening if the system is working. And we don't seem to care. I mean, I found it horrifying. And I have to say this because Mr. Niranjan has been at the forefront, speaking about this project, promoting this project, sitting with the government and working on this the medical thinking, the body care or whatever it is of that. He's been advising the NPCI. So he's been at every one of these things. On that fintech with Chandrababu Naidu as the chairperson. So he's been on every one of these. In a recent interview with Visa, he was asked, there are, a child dies because she's not able, because the number cannot be reached, the UID number cannot be reached. Doesn't it bother you? And he says, yeah, but you have to see what he kind of punches a bit and says, maybe I don't want to get into a debate with you. Then Visa comes back to that question again later and says, but then the child is also dying in this. And he says, you have to see it in perspective. So you see it and you get the exact words. He says, so you can't take anecdotal evidence. You have to look at what the studies say. What is the study? The study that he refers to is a state of Aadhaar report, which is funded by Vindhya, whose one task after this project has started openly. This is not something that we are, we're figuring out. They openly said that they are here to help promote the UI. Now, with that kind of a report, you tell us that you're not even going to talk about the death of a child. There's something wrong with it. There is something wrong with a psyche which refuses to acknowledge this. And if that's how this project has progressed, we're really in for many, many more shocks. Right at the beginning, when Aruna Roy, Nidhi and I were conversing about this in 2010, we were saying at that time we were saying that if this project, given that manual workers will use their hands, you can't tell them to protect your hands so that you can come and give your fire. People working out in the are working under the sun, people who are malnourished, their eyes will not work the same way that somebody else's will. Now you say virtual ID. Who's going to be able to use these virtual IDs? You may be able to use it because your eye can't right now. There are many others who can't. So it's not just about protection, it's about use. You have no ability. So we were saying even then, then it was just these two. We said this is like asking for some kind of class genocide. Where you say that well, if you can't prove yourself that you're not entitled to this, manual workers are never going to be able. 2011 November, Mr. Ramsey Sharma, when he was the chairperson of the UIDAI, not chairperson, he was the mission director of UIDAI, he gives an interview to Frontline and says somehow we might be able to manage to enroll people, but when it comes to authentication for people like manual workers, it could be a problem because there will be all rough edges and all that. So that's it. And then much later, when it seems like they have to expose their biometric database because of the court order, they then reveal that they have plans for a UBCC to be set up. What is UBCC? UIDAI, Biometric Center of Competence. And the next thing under that is research. Why? Because the nature and diversity of India's working population makes biometrics a challenge. When is this put out? 2015, 5 years after you started collecting it, and 2.5 to 3 years after you started using biometrics as the means for people to go and authenticate themselves. What do you say today when you say that the biometric is not working? You say, oh, well, if it's not working, we have told local authorities that they must give them the entitlement anyway. You go and ask the local authority, they say, okay, 10 people we can give, 15 people we can give, but if the number goes more than that, then they tell us we are corrupt. So we can't do this. This is the system that has come in place. So, I was very keen on coming here to speak to you also because I feel there is value in technology. I'll give you one example of the kind of value that I find. You would all have read about the Vindhya experiment and actually putting in place a technology that uses AI also on using artificial intelligence and different elements of it in cleaning sewers. Right? Sewer lines. You know how many sewer line deaths happen? Every other day, you have 3 people dying here, always multiple deaths. Sewer line deaths have become so common. The last time that the persons in Madras University put out, in 2014 they got a judgment from the Supreme Court. Yeah, 2014 they got a judgment in March, where the court said that Madras University is untouchability, and if any person dies when they are going to cleaning the sewer, their family should be paid 10 lakhs. Now this is much better than what was before. But in 2015, those who, the persons from the community started saying, okay, it's all very well you pay 10 lakhs, but have you valued our life at 10 lakhs and then you put us in, kill us and then give 10 lakhs? Stop killing us. So that was their motto in 2015. By now, the idea that it is possible, so they got this equipment which is placed just inside the manhole cover, and that is able to detect when there is, when the water rises too high, and when there are any gases, if there is any impediment, and it also has, it's like an octopus, it also has tentacles that it can put out, and some part of this can be done by the machine itself. In the event that it's not able to complete the task, it's able to get this thing of alerting somebody. This is a use of technology that we will all appreciate. This is artificial intelligence. This is technology. And this has a problem that it is addressing. The UID came saying, I am the solution for a problem